The next case to come before the court is Isaac Roth v. Denise Roth. You may be seated. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. And if you do plan to reserve time, please let me know, as I will be keeping track of the time. Just to remind you, the arguments are being recorded. Please keep your voice up and remain behind the podium. We always advise, regardless of the case, you should not use the names of children, minors, and victims during your argument. You can refer to them by initials or generic terms like the child. The judges have read your briefs and are ready to proceed when you are. And at this time, I would like to ask the appellant, would you like to reserve time?
Yes, sir. I'd like to reserve 5 minutes.
Very well. And please introduce yourselves when you come. You're ready to proceed? We're ready for you.
Morning.
Good morning.
Your Honor, Counsel. My name is Brian Smith, and I'm appearing on behalf of the appellant, Isaac Roth. I'd like to reserve 5 minutes for rebuttal. Your Honors, there were 2 assignments of error in this case. I'd like to touch on, first of all, the factual findings that were as part of the court's decision here. The trial court concluded incorrectly that there was that the appellant, that father had, quote, no control over his behaviors with respect to his diagnosis. In doing this, the trial court essentially ignored the testimony that came before it in the form of Dr. Sibilia, the appellant's expert. This is a medical professional who had met with the appellant approximately 6 or 7 times, had been meeting with him for a considerable period of time prior to trial. This is someone who had actually studied appellant, done a polysomnography with him, at one point gave him an actigraphy watch to keep track of his activity while he was asleep. So there was substantial medical testimony as to not only what the diagnosis was, but how it could be controlled and how it could be controlled in a way that would allow appellant to safely have parenting time with the children.
Overnight parenting time. He had an order for parenting time.
Correct. Yes, this was about overnight, Your Honor. I don't believe there was any dispute as to daytime parenting time. However, it brings up a strange dichotomy or contradiction in the appellee's argument, because essentially what the appellee's doing is they have one foot in both camps here. They're either arguing that there's no control over the behavior and that there was sexually aggressive behavior taking place during the day, or they're saying that there's a diagnosis of sexsomnia, which makes it impossible for the appellant to safely have, or for father to safely have parenting time with his children at night. And the problem is both of those things can't be true. He either has sexsomnia or he doesn't. And so if it's not sexsomnia, why deny him visits? And if it is
sexsomnia?
Yes, yes, there was a diagnosis of this.
We know he has it. It doesn't matter, despite what they may or may not be arguing, whether he does or doesn't have sexsomnia. He has it. And the question is he adequately treated for it? Yes,
he has it, and he is being treated for it. And that was the testimony that was in the record from Dr. Sibilia, who had not only treated him, but also provided information about the diagnosis, what it was, and what was being done to address it. What the court needed to do here is look toward the future, not the past. This was a situation where obviously there had been some issues here leading up to the divorce. There have been some issues with that both parties were alleging that there had been abusive behavior. On mother's side, she's alleging sexually aggressive behavior. On father's alleging that mother had been aggressive toward the children. The important thing here is for the court needed to look toward the future, not the past. And what needed to happen in order for first and foremost for the children to be safe, and also to protect the right of the father to have this parenting time with his children. And the court did not do that here. The court, especially on the second part, and that's what rendered this decision not only an abuse of discretion, but also with respect to the factual findings against the weight of the evidence here. The fact that I'd also like to talk briefly about the report from Dr. Tenner. Dr. Tenner, this was a parenting evaluation done, not a medical report. I think that's an important distinction to make here. Dr. Tenner did not present themselves as a sleep expert. A parenting evaluation is not going to carry the same weight, and frankly shouldn't have carried the same weight as a medical diagnosis or a medical report or some form of medical documentation as to what this condition was. The parenting evaluation is not, the trial courts, one of their principal errors here was in assigning as much or greater weight to Dr. Tenner's parenting evaluation, who was a witness that didn't even testify at the trial, than Dr. Sebelia's expert testimony, who did testify at the trial, had treated father, and could provide expert medical testimony on what is admittedly a very rare condition. The other aspects.
Counsel, what did the guardian recommend regarding father's overnight visits?
I'm sorry?
What did the guardian ad litem recommend? There was a guardian in this case, as I recall, correct?
Yes.
What did they recommend regarding father's overnight visits?
I believe that they recommended. I believe they had recommended supervised. I believe. Supervised overnight visits. I believe so, Your Honor. I'd have to double check that. And the problem was here also that the trial court had another option, which was to carve out visitation with the grandparents to allow father to see the children. Even that was not done. So I think we would argue that further underscores the abuse of discretion here, because there's even a third road that the court could have taken here to not only address the medical situation, but also to make sure that father's parental rights were protected, and the court, for whatever reason, chose not to do that. So I would reserve the remainder of my time for rebuttal, but I'd be happy to take any further questions from the court.
Any questions? Thank you very much, counsel. You'll have 5 minutes for your rebuttal.
Please report, counsel. My name is Bing Miller, and I represent Denise Roth in the matters before the court today. I'd just like to address a couple things that came up during the appellant's argument. Currently, I believe there is a grandparent's visitation motion pending right now. Also,
Was there one pending before this decision was made, and was that ruled upon? Is there a new motion? Kind of what is this?
It was not ruled upon.
Okay.
It was filed, I believe it was filed before. It was filed after trial.
You're not, I thought from the brief that there was one pending, but if there was, it was not ruled upon in this decision.
Correct.
Certainly, that is still pending. Okay.
Right. And grandparents reside in Iowa. What's interesting in this case, I believe that the appellant is arguing that in some way Ms. Roth wants to have it both ways. That's not the case. The evidence that was before the court at the trial of this matter was that Mr. Roth had a difficult time containing himself sexually. The testimony showed that from 2013 until the party's separation in 2020, there was sexually aggressive behavior throughout that period. The parties were counseling. There were several safety plans that were developed, and Mr. Roth violated those repeatedly. And as to sexomnia, the evidence at trial was that this diagnosis was entirely on the self-report of Ms. Roth. There was testing done, but the testing did not disclose anything abnormal, which according to the doctor is normal. Oftentimes you don't see any problems with sleeping, but you could still have a parasomnia or sexomnia, as in this case. And I think Dr. Kenner's report, and throughout the proceedings, there's different trial counsel from Mr. Roth has complained about the fact that Dr. Kenner didn't testify at trial. Well, Mr. Roth did not call him to testify at trial. I mean, he obviously had that right, he chose not to. The parties had agreed that the report was going to come into evidence and that we did not have to present the testimony of Dr. Kenner at the hearing, that the court was going to take a look at the report. And the report had concerns about the sexomnia diagnosis. I obviously couldn't question it because that's not her expertise, but called into question, well, if Mr. Roth is having problems acting out sexually during daylight hours, and it's a cross-examination of Mr. Roth, obviously the court has before it, he admitted that this behavior, and the parties were disputing that this was an ongoing problem.
Dr. Tenner was aware of the sexomnia diagnosis when she made her report.
Yes.
Was she aware of the, I'll call them remedial actions or the treatment that Mr. Roth was beginning before she made her report?
Yes.
And how about the guardian? Was the guardian also aware?
Was aware of that.
Of
it's
all
my
those?
understanding that the guardian was recommending that there be no overnight visitation. I don't believe she was recommending supervised visitation. I may be mistaken about that, but I don't believe so.
Counsel, could you talk up just a little longer? Speak up just a little bit more. I'm sorry, not longer. Talk a little longer. Speak up a little more.
I will try to keep my voice up.
So what did the guardian recommend?
The guardian recommended, I believe, that there be no overnight visitation. And Dr. Tenner recommended that there be no overnight visitation. And obviously the magistrate and the court, after reviewing this matter, found that there should be no overnight visitation. And I think at the time that those decisions were made, that was absolutely supported by the evidence in the record.
And what is father's visitation schedule, not overnight? Is it every other weekend for all time during the day on that?
Yes. And the matter was pending for about approximately a year, and there was a temporary visitation schedule, and that gave father every weekend, but no overnight. And mom, that puts a lot of strain on the other parent because she had no weekends for that period of time. Plus, she had to be available for all the overnights, which she was willing to do. It was her position that was the safest for the children. But to say that Mr. Roth hasn't had contact with his children, or he has had ample opportunity for parenting time. It's just been, due to the facts of this case, found to be in the best interest that there be no overnight. So I think it's important for the court to realize that the standard of review is abuse of discretion, and also to recognize how difficult it is when the trial court is making parenting time decisions and custody decisions, that the trial court is the one that has the opportunity to see the demeanor of the witnesses, to hear the testimony. And I think in this case there was ample evidence to support the trial court's decision that there be parenting time, that there be no overnight parenting time. And obviously that's something that, if things would change, Mr. Roth can file future motions to seek change of those if it would be appropriate. But based upon the state of the record at the time these decisions were made by the magistrate and the trial court, it was based upon the facts and circumstances at that time, it was a reasonable decision. And I don't believe that it should be overruled. Thank you.
Thank you, counsel. You will have your full 5 minutes, please.
Thank you. One of the grandparents actually testified at the hearing, so there was a possibility of grandparent visitation. Obviously, the grandparents resided out of state. However, the court still could have carved that into the decision in some way to allow father to have some form of overnight parenting.
Did grandparents have a visitation motion pending before this decision was made?
I believe there was, Your Honor. I know there was testimony regarding it. I'm not sure if there was an actual motion that was pending, but I believe there was some testimony in the record to that effect. And it's also important to point out, there was medical testimony as to this sexomnia condition. There was a specific diagnosis that had been made. There were specifics as to how the condition affected father. I believe that Dr. Sibilia testified that it tended to affect him during the first third of the night, that it tended to be triggered by things such as stress.
But also the medical testimony, the expert testimony also said that there's no cure for this.
Yes, I believe that was an indication. However, it was indicated that it was a manageable condition.
But that they really couldn't predict what would happen at this point, only because he has not had a sexual partner since his wife.
Well, it's
Or somebody sleep with him at least at night, other than his wife.
that may be the case, Your Honor. However, it's also important to point out that none of this behavior was ever directed at children, and I think that's an important distinction to make here. Except
that the whole diagnosis is they have no control, no knowledge of it. So how would he know if it's a child or it's a full-grown woman beside him, or a male for that matter?
Well, because he's had, essentially he had overnights for years, and when he was struggling with this condition, and there's never been any allegation that anything inappropriate has happened between father and the children. I think that's a very important distinction.
Counsel, I seem to recall that, if I'm correct, or if I'm not, you correct me, that there was some issue related to a co-sleeping incident with one of the children.
Yes, Your Honor, it was pages 142 to 144 of the transcript. However, the inappropriate behavior did not involve the children. I believe it was a situation where he was sleeping in the same room as the kids, and then acted out in a manner that was directed at mother, not at the children. To the best of my recollection, that was how the episode played out. It was not directed at the children, however.
But I think Judge Sutton may be referring to an episode that was in, I think, both your briefs that referred to a night when the child actually slept in the same bed with father. Not alleging anything happened, but I know the allegation was that was very poor judgment. If somebody has sex in Amia, to allow a child to sleep with him.
Yes, I believe there was a co-sleeping incident. However, we would stress that nothing inappropriate took place there, and frankly, that if this is a condition that he was suffering from at the time, actually underscores the fact that this isn't a threat to the children, because it was directed at mother, at the time his normal sexual partner, not at his children. So I just want to, very briefly, with respect to the guardian's report, even if the guardian's report said no overnights, the recommendation isn't necessarily the last word. It does carry considerable weight with the court. However, the court still has to act in the best interest of the children, and also in a manner that protects the parental rights, the due process parental rights of both of the children. We would submit that in this case, the trial court abused its discretion in foreclosing any possibility of overnights, especially when there were other frameworks or other means available to make that happen. Very briefly, with respect to calling Dr. Tenner as a witness, The report was never technically stipulated to. There was discussion in the record that appellant's trial counsel knew the report was coming in. There was never an objection made to the report. However, there was not a stipulation to it. Procedurally, the only way that appellant's counsel or the appellant's trial counsel could have called Dr. Tenner would have been as a hostile witness, which would have required surprise and affirmative damage under 607. So the possibility of calling Dr. Tenner as a witness was simply not there under the circumstances.
And counsel, your time is up, so if you would like to, thank you.
Thank you, Your Honor. We would ask for reverse remand. Thank you.
Thank you. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of that decision to you on the day that it is released, and the opinions will be posted on the Ohio Supreme Court website. Thank you.